Hello, my name is Kim Basto. In this presentation, I will review a news story published by ATPN News on May 2, 2019. The story covers a policy forum held by the Assembly of First Nations to discuss 4 key policies on Indigenous rights and self-government. During the policy forum, Carolyn Bennett, the Minister of Crown Indigenous Relations for the Government of Canada, announced that they would be issuing a cabinet directive to public officials and federal staff who are negotiating self-government agreements with First Nations. The anticipated directive would ensure that federal staff would no longer negotiate agreements from the position of cede, surrender, and extinguishment of First Nation lands, rights, and title. This particular point goes to the heart of the Crown's colonial approach to date, which is to extinguish First Nation rights. Before diving into the Cabinet Directive, it is important to provide some historical context regarding the Crown's approach to extinguishing First Nation rights. The main issue is the use of the doctrine of discovery from the 15th and 16th centuries, when European countries were sailing to find new lands. The doctrine essentially states that the first European nation that came upon the shores of new lands was able to claim title and possession from any other European nation. The doctrine gave the discovering European nation the exclusive right of acquiring the soil from the native inhabitants. This doctrine has proven to be the very essence of the Crown's argument that it has sovereignty, land ownership, and political authority over First Nations peoples in Canada. A second historical issue to consider is the signing of treaties. For the purposes of this presentation, we are focusing on the historic numbered treaties colored in light green here on the map. Beginning in 1871, the Crown sought to create formal agreements to acquire Aboriginal lands and resources. The text of the treaties was drafted to indicate that all Aboriginal title was surrendered to the Crown, and that from those tracts, lands were set apart for reserves on a population-based formula. Aboriginal people had a very different understanding of the treaty process. Many nations understood that the Crown's intent was to share the lands with Aboriginal peoples, but that the lands would not be surrendered. First Nations did not agree to give up jurisdiction or authority over their lands and people. Fast forward to 2019 in the Assembly of First Nations Policy Forum. The Assembly of First Nations convened the forum to facilitate input on Canada's intent on revamping the following policies. The Comprehensive Land Claims Policy guides modern treaty negotiations and applies in cases where Indigenous rights and title haven't been addressed through historic treaties. The policy largely applies to First Nations in British Columbia, the Yukon, Quebec, and Canada's North. The Inherent Right Policy addresses the right of Indigenous peoples to govern themselves in relation to matters that are internal to their communities. The Specific Claims Policy settles historic grievances by Indigenous communities against the Government of Canada that relate to the administration of land and other First Nation assets. The Additions to Reserve Policy enables Canada to fulfill legal obligations established by specific claims or treaty settlement agreements. An addition is a parcel of land added to an existing reserve or that creates a new reserve. For this presentation, the Inherent Right Policy is the most applicable. Canada's Inherent Right Policy was first announced in 1995 to guide self-government negotiations. In it, Canada recognizes that Indigenous people have an inherent right to self-government, guaranteed by Section 35 of the Constitution Act of 1982. Negotiated agreements puts decision-making power about local issues into the hands of Indigenous governments. Under self-government, First Nations move out from under the Indian Act. This means that communities can incorporate their own governance structures and deliver services in a manner that aligns with their traditional customs. There are currently 22 self-government agreements across Canada, involving 43 Indigenous communities. These agreements have all been completed in conjunction with a comprehensive land claim. Most completed self-government agreements have been tied to those areas that are not covered by historic numbered treaties. First Nations have been critical of the policy. The policy does not recognize First Nation sovereignty. Sovereignty means that First Nations govern themselves as a nation. They have the right, power, and authority to administer and operate their own political, legal, economic, social, and cultural systems. It also means that First Nations do not need to ask the Crown to be self-governing because they are a nation before Europeans came to Canada. The Inherent Right Policy essentially delegates powers to deliver local programs and services to First Nations without any true authority to create systems that will meet the needs of their particular community. Signing a self-government agreement provides for a new fiscal agreement between the First Nation and Canada. This approach is focused on capacity building and long-term grants. The existing system is not restructured, however. First Nations are not provided with sufficient funding to meet basic needs. Some First Nations have indicated that self-government will not truly be recognized without the nation being economically sustainable, which may include having more lands available to conduct economic development activities. On May 2nd, at the Assembly of First Nations Policy Forum, Minister Bennett announced that the Cabinet Directive will be provided to federal negotiators who are co-leading self-government tables with First Nations, respect to the United Nations Declaration on the Rights of Indigenous People, indicate to all negotiators that federal positions related to cede, surrender, and extinguishment of Indigenous rights and title will be removed. All negotiations will begin from a blank piece of paper with a mandate co-developed between Canada and the Indigenous community, and all Indigenous communities will receive funding to participate. An important point is that the directive will replace the existing inherent right policy that we've just reviewed, as well as the comprehensive land claims policy. The issuance of the Cabinet Directive may create several opportunities. First, it may re-establish a relationship between First Nations and the Crown in a manner that seeks to be more respect-based than in the past. It also may allow more First Nations to participate as funding is being provided. Second, the mandate for each table will be co-developed, allowing First Nations to focus on areas of importance to their specific community. This may allow for unique discussions and agreements that reflect the needs and desires of individual nations. Third, the directive will be drafted to respect the United Nations Declaration on the Rights of Indigenous Peoples. The Declaration is the leading international standard for Indigenous rights, and one that First Nations have indicated is the minimum standard Canada must implement. First Nations can ensure Canada is diligently implementing the Declaration into Indigenous rights issues. There's also a need to review and consider potential implications of this Cabinet Directive. The main point of the directive is the elimination of the Crown's position of cede, surrender, and extinguishment of title and lands. It is unknown what limits or conditions Canada may or may not impose on the discussions related to this new position. This directive may change or influence the interpretation Canada may have on the historic number treaties. The treaties were written in a manner that surrendered all lands, title, jurisdiction, and authority to the Crown. The directive may indicate that Canada is moving towards an approach of providing more autonomy and authority over lands and traditional territories to First Nations who seek to sign a self-government agreement. However, the directive may also work to undermine the spirit and intent of the treaties and Canada's constitutional obligations to First Nations who are adherents to treaty. A second implication is that to date, self-government agreements that are signed outside of the comprehensive land claims process are not protected as Section 35 rights. For First Nations that are adherents to treaty and already have reserves, any self-government agreement will not be protected under the Constitution. Finally, in the pursuit of self-government, it appears Canada is focusing on creating sectoral agreements on specific issues. The directive is encouraging First Nations to sign agreements on issues such as governance, child welfare, language, education, healthcare, and other programs and services. This approach does not meet the needs of First Nations who seek the authority to govern themselves without interference of the Crown. In reviewing the main points, it is this presenter's conclusion that the directive is another empty policy to illustrate the Crown's attempt to meet the needs of First Nations without actually moving forward in true partnership. It is clear that First Nations want Canada to honour its constitutional obligations that affirm First Nations' inherent rights, treaty rights, and title. Such rights cannot be negotiated through agreements, settlements, or arrangements. Under this Cabinet Directive, First Nations will still have to ask Canada for authority and jurisdiction over its lands and peoples. So what can the Crown do to work with First Nations to be truly self-governing? This presenter takes a quote from the Royal Commission on Aboriginal Peoples published in 1996, which states, "It is time to return to the spirit of the treaties and to set a new course to correct the legalistic and adversarial attitudes and actions that have contributed to the badly deteriorated treaty relationship that exists between First Nations and Canada today. To truly enable self-governing First Nations, Canada must go back to the beginning, to rebuke the doctrine of discovery, and to implement the spirit and intent of the treaties. This means coming to the table to have a mutually beneficial relationship, where both governance structures can coexist. The Crown must relinquish its colonial ways and treat First Nations as partners." Thank you.